Thank you. Good morning. Yeah, that's better. I'm Hanale Fergerstrom. I'm with Nakupunamoko Kiavi, and I wanted to speak on these various cultural ideas of how we're going to try to work together on this particular issue. First of all, I'd like to say that I believe this is out of order at this time. We still have cases in the Supreme Court that deal with these exact items. Not necessarily in the finality that you're speaking of, but a lot of it has to do whether or not you're even going to be able to continue on the mountain. I would also like to say that, and I'm sorry I missed Vince, I think, this morning at Kaukumana. However, I did put in my application in January and have not even had the courtesy of a return call or anything saying that my application is pending. I like to have something like that so I know where we stand. I brought to the attention of Mr. Gregory Chun this morning a memorandum from the United Nations on Human Rights. If you don't mind, I'd like to read that to you because it applies directly here. It'll only take a few moments. Yes. Okay, this is from the High Commission from the Human Rights of the United Nations. It's a case regarding Ruth Bulliman. She's a Hawaiian national and Swiss national also. It says, as a professor of international law, and former secretary of the United Nations Human Rights Committee, and co-author of book United Nations Human Rights Committee Case Law 1977 to 2008, and currently serving as the United Nations independent expert on the promotion of a democratic and equitable international order. I've come to understand that the lawful political status of the Hawaiian Islands is that of a sovereign nation in continuity, but a nation state that is under a strange form of occupation by the United States resulting from the illegal occupation and fraudulent annexation. As such, international laws, the Hague and the Geneva Conventions require that government and legal matters within the occupied territory of the Hawaiian Islands must be administered by the application of the laws of the occupied state, and in this case it's the Hawaiian Kingdom, and not by domestic laws of the occupier, the United States of America. Based on these understandings, in paragraph 69N of my 2013 report to the United Nations Assembly, I recommend that the people of the Hawaiian Islands and other peoples and nations in similar situations be provided access to the United Nations procedures and mechanisms in order to exercise the rights protected under international law, that adjudication of land transactions in the Hawaiian Islands would likewise be a matter of Hawaiian Kingdom law and national law, not United States domestic. Those are the most important parts of that letter, so I'll leave the rest of that out. But again, I would like to say that this, I know we've tried this before. I've been in both meetings where we tried to move these things along. I believe they need to have a lot more careful thinking about this, because it is, when you make a document like this, it continues on, and our predecessors or our future persons may not understand what went into making such a rule if we decide we're going to make rules. But again, as I say, there are Supreme Court cases that directly deal with some of the papers that we use to work with, according to the master plan and such. Yes, so at this time I'd like to say that this is untimely. Thank you.